Further hearing the appeals Micula and others against Romania.
Lord Mayor, good morning. I indicated yesterday I would hand up a copy of the Court of Justice statistics, and if I can do that before we get into the trenches. And the headline point is the average delay of appeals from the General Court to the Court of Justice is 13.4 months. Given that the appeal was lodged in August, we have about a year to go, at least based on these statistics. And to be fair to Ms. Dimitriou, the average delay has sorry, let me make sure you've got that first. So the court will see from the cover page, this is the annual report on judicial activity of the Court of Justice, and then over the page, the last column on the right, bottom row appeals, 13.4 months. And to be fair to Ms. Dimitriou, the court will see that the average delay, at least relative to 2017, has reduced pretty substantially. But the current delay, at least for 2018, is 13.4 months, so about a year. And to be clear, the only order I seek today is a stay until the Court of Justice judgment, and as I indicated yesterday, it may be depending on political events for the next several weeks that the stay in practice is even shorter. My approach is based on taking this in bite-sized chunks and incrementalism. Nobody is seeking a permanent injunction. Turning back to the grounds of the cross appeal, if I can start with ground one. The court has my headline submissions from yesterday. The Micula parties have submitted with various adjectives and slogans that ICSID enforcement is automatic, it is a complete code, and that the stay is permitted in very limited circumstances, and so on. And in our submission, that legal question cannot be decided by slogan or moniker. It requires an interpretation of the domestic law, in line, of course, with ICSID, and any further relevant interpretive obligation, including, of course, EU law. Starting with ICSID itself, in our submission, it is manifest from the history of the Convention that the authors were fully aware of the possibility that a final judgment might not be enforced in certain circumstances, and they accepted this. And if I can quickly show the court three documents, it's Authorities 13, and if we can start at tab 185, it's MS 3942, and the court will see the title Awards Remedy pursuant to ICSID, Binding Force, Finality, Recognition, Enforce and Execution. And the author is important. It may be known to the court. It's Aaron Brosh, and the court will see from the notes at the bottom of the page, the last paragraph, Mr. Brosh was in charge of the World Bank staff working the convention, was chairman, and so on. And you will see then from the, under the asterisks, he was general counsel of the World Bank from 1959 to 79, so he was at the coalface for the critical period in historical terms. And the point I wish to pick up on is that MS 3969, it's about a third of the way down. So the Austrian delegate suggested the deletion of the words as if it were a final judgment of the court of that state, since the final judgments could be annulled in certain instances. Replying, Mr. Brosh, I said that in my opinion, by making an award the equivalent of the final judgment, one had reached the maximum obtainable. And then at MS 3967, back a couple of pages, again a third of the way down, the United Kingdom had been satisfied with the text of the first draft, which stated that awards should be treated in the same way as judgments of the courts of the countries concerned. And Brosh says, I said that the first draft went further than the Secretariat draft, since treating awards in the same way as court judgments implied that exceptional grounds only could be invoked to prevent recognition and enforcement. And in response to my Lord Reid's question yesterday, at least at that time, the United Kingdom seemed satisfied with that state of affairs. Second document, tab 192 in the same bundle. This time MS, this is a report of the executive directors of the ICSID Convention. If I can direct the court to paragraph 43 on MS 4107. Top of the page, Article 54 requires contracting states to equate an award to the convention with the final judgment of its own court. It does not require them to go beyond that to undertake forced execution of awards rendered pursuant to the convention, cases in which final judgments could not be executed, and the court will see a reference to immunity. The third and final interpretive historical document I wish to show the court is the ICSID commentary from Professor Schroyer. That is next tab 193, MS 4155. Bottom of that page, paragraph 91. Professor Schroyer said, the fact that Article 54.1 assimilates ICSID awards to final judgments in domestic courts implies that enforcement may be resisted in countries where national rules provide for exceptional refusal to enforce a final judgment. And then he makes the point, which is fair, although this possibility was already acknowledged during the drafting, it has not yet been relied on in practice. And the court will then see at footnote 106 reference to the Brush article we just looked at, where he says treating awards in the same way as court judgments implying the exception grounds only could be invoked to prevent recognition and enforcement. So we say, based on those three documents which do assist with interpretation, it was fully recognized and accepted that at least exceptionally, if there were grounds under national law for enforcement to be delayed or conceivably halted, that was perfectly within the compass of the convention and was understood and accepted. And indeed, we say this is an unsurprising conclusion in many ways. ICSID deliberately left the enforcement procedure and process to national law. There are 170 signatories to ICSID with a diverse range of legal systems and rules of civil procedure. And in particular, as we see in Article 54, there was a recognition that in federal systems, the judgments would have to go through a somewhat different process of enforcement at a state level. And we say it would be surprising that in a convention that does not touch on national procedural rules in any way, that according to the Micula's parties, all of the national court's usual procedural powers would be disabled, save in the very narrow exception they admit of under Article 53. Turning, if I may, to public policy, we do say that one needs to be careful and precise in relation to public policy. A small but not unimportant point, the ICSID Convention itself does not use the words public policy. When it is said that ICSID is a complete code, in our submission, what is meant is primarily two things. First of all, ICSID has an exhaustive set of internal appeal rules that preclude further substantive challenge or remedies to the award outside the scheme of ICSID. See in particular Article 53.1, and we agree with that. And second, ICSID is a comprehensive code because it includes a package of different measures, which include convention, administrative and financial regulation, rules of procedure, rules of conciliation, and rules of arbitration proceedings. So it is self-contained to that extent. However, when it comes to enforcement of an award, ICSID, in fact, says very little indeed. The court saw this yesterday. Article 51 says, and I quote, each contracting state shall recognise an award rendered pursuant to the convention as binding and enforce the pecuniary obligations by that award within its territories as if it were a final judgment of that state. And then Article 54.3, execution of the award shall be governed by the laws concerning the execution of judgments in force of the state whose territories execution sought. Mr. Green made the point yesterday that a stay is only permitted within the terms of ICSID under Article 53, and that there is no further domestic power to stay beyond this. But we make the point in our written case that unlike Article 53, Article 54 of ICSID is not qualified by the words except to the extent that enforcement shall have been stayed pursuant to the relevant provisions of the Convention. And we say, as a result, domestic provisions must be interpreted in a similar manner. And it cannot be said at this stage that the United Kingdom is in breach of any of these ICSID obligations. The United Kingdom has recognised the award. There is no challenge to that. The United Kingdom has not said it will not enforce the award. It has temporarily stayed its enforcement and put in place a facility whereby that stay can be lifted if circumstances change. That, we submit, is consistent with the terms of Article 54.1 and 54.3. Now, it is true, of course, that the United Kingdom could not adopt new statutory rules providing for a substantive review procedure at the enforcement stage on New York Convention-type grounds. But no one is suggesting, or has suggested, that the United Kingdom has done this, or is being asked to do this via the stay application. We say it is not particularly useful, relevant, or accurate to say that the United Kingdom, in imposing a temporary stay, is thereby applying public policy in a manner contrary to ICSID. We say the correct characterization is that the United Kingdom courts rightly perceive a risk of conflict between two international treaties and a realistic prospect that that conflict might disappear if the Commission decision is ultimately annulled. We say it is a perfectly legitimate exercise of the English court's powers to have such a hiatus, since it is common sense and tried law that the court will strive to avoid a conflict between international treaties if that can reasonably be done. We say a stay is part of the court's general case management powers in this context over the process of enforcement, and these powers are not only not displaced by ICSID, but as we saw, ICSID defers to them as a matter of national law. ICSID does not oust the national court's ability to control its own process of enforcement, including in particular in relation to a temporary stay. So we do say that purely as a matter of domestic law, interpreted in line with ICSID, even before one gets to the European dimension, it is plain that there is a power for the English courts to impose at least a temporary stay, which again is all that is at issue today. Now, Lord Readon, President, asked yesterday about the history of the drafting of the CPO, particularly Section 2.2 of the 1966 Act. And what we've done overnight is prepare a short note on that history. I don't propose to go through it now, but it does respond to the court's questions. I will deal with my essential submissions as I proceed, but in terms of the history of the relevant provisions of the CPO and the rules of Supreme Court, this may be of some use.
Has this been agreed with the other side?
I let you know.
Have they seen it?
They know it's produced overnight.
Do you have any objection to our looking at this?
Just been handed it, so I don't know what's in it. What I would propose is that the court looks at it, we look at it, and if we have any comments, we respond in due course.
Deep ideas, eh?
now turn, if I may, to the European dimension, which we say that when one considers in the context of the power to stay, the European dimension, the case for a temporary stay becomes unanswerable. And we say the court has to consider, of course, obligations under the 1966 Act as interpreted in line with ICSID, but also other relevant legal obligations, including on the European dimension. 5 submissions, if I may. First, sincere cooperation has a mandatory impact as a matter of EU law on the court's case management powers and obligations in certain circumstances. And if we can go back to the Master Foods case, which was addressed yesterday, it's Authorities 7. Tab 100. Now, I will not repeat the factual circumstances of the case, but in brief,
We have the MS page number, sorry.
1844.
Thank you.
Ms. Dimitri outlined the factual circumstances in 2 sentences. There was competition litigation in the Irish courts about a freezer exclusivity clause in the agreement, and then in parallel, the Commission had proceeded to adopt a decision condemning the exclusivity provisions, and the Irish Supreme Court asked the Court of Justice, well, what, if anything, are we required to do with our pending appeal in the context of sincere cooperation? Well, I can start at paragraph 49, MS 1860. So this is the overarching obligation. So it's a reference to Article 5 EC, which should now be Article 43 TEU. So the obligation is to take, on the national court, to take all appropriate measures, whether general or particular, to ensure the fulfillment of the obligations arising from community law, and to abstain from any measure which could jeopardize the attainment of the objectives of the treaty. So that is the overarching question on sincere cooperation. And then over the page at 51 and 52, so the court in 51 mentions the principle of certainty and avoiding conflict with the decision contemplated by the Commission. And then 52, even more important, where the agreement or practice is already subject to a Commission decision. It cannot take a decision counter to that of the Commission, even if the latter's decision conflicts with that of the National Court of first instance. And then at 54, if a national court has doubts as to the validity or interpretation of a decision or act of the institution, it may or must, in accordance with the 2nd and 3rd paragraphs of what was then Article 177, refer a question to the Court of Justice. Now, the point I want to pick up on in particular, following on from Mr. Dimitri's submissions yesterday, if one goes back to paragraph 18(1)(a), which is MS 1851, and you will see that the Supreme Court's question, A, the obligation of sincere cooperation, required the Supreme Court to stay instant proceedings pending disposal of the appeal to the Court of First Instance against the aforesaid decision of the Commission, and any subsequent appeal to the Court of Justice. And one can then track the Court of Justice's answer starting at 57 MS 1862. And the court will see about half of the way down, it says, pending final judgment in the action for annulment by the community courts. So it's oh, forgive me, it's paragraph 57, 1862, about halfway down, National Court should stay its proceedings pending final judgment in the action for annulment by the community courts, plural. And there really is no doubt in this, because if one then goes to the disposal of the case at the end, MS 1865, again you will see the last sentence, pending final judgment in that action for annulment, or in order to refer a question to the court for ruling. Now, while we have MasterCards in front of us, there's a further important point. Paragraph 53, MS 1861, because the point was made by the Micula parties, well, the Commission didn't apply for interim relief, and that makes all the difference at this stage. But if one sees in Master Foods itself, the Commission decision in that case was suspended by the Court of First Instance, and the Court of Justice said that is irrelevant, and about two-thirds of the way down, because it only has provisional effect. It is not prejudging anything. So we say the absence of interim relief is essentially a neutral point in this context.
So sorry, I missed the MS page for...
My Lord, it's 1861.
Whereabouts? Which paragraph?
53.
Well, the reasoning applied to this case would imply that the decision of the General Court is presumed to be lawful.
Well, there had been no decision by the General Court. There was an application for interim relief which was successful.
Yes, in that case, what was being presumed to be lawful was the decision of the Commission.
Yes.
Notwithstanding the fact that it had been suspended by the CFI.
Yes, that's fair. But
The analogy in the present case would be that the absence of whether or not the judgment of the General Court has been suspended, it's in any event to be presumed to be lawful.
Well, Lord, if one thinks of this in terms of sincere cooperation, what one is ultimately concerned with, is there a realistic risk of conflict? And we say with respect that the Micula parties are looking at the wrong end of the telescope. The correct way to look at this today is that there's an extant appeal to the Court of Justice that stands a realistic prospect of the Commission decision being ultimately vindicated. And on a prospective basis, that is the sincere cooperation issue for the Court today. And we say in that context, the fact that pro tem, the decision or the judgment or its effects, have or have not been suspended, is really a second-order consideration. I mean, ultimately, the Court has to make a pragmatic decision to deal with the potential for legal uncertainty. And I'll come to this point, but we say sincere cooperation is essentially prophylactic, that one only proceeds where the risks of proceeding are essentially minimal or non-existent. But I will come to that. Now, as I indicated yesterday, of course, an order whereby a second instance appeal to the Court of Justice would lead to a stay of national court proceedings is entirely uncontroversial. Each and every follow-on damages case I have done for the last several years, these stays are agreed as a matter of course. And one can test the analogy this way. Suppose I had a damages action relying on a Commission decision, and that decision was annulled by the General Court at first instance, but there was an appeal. If I applied to strike out the claim on the basis of the first instance ruling, am I likely to meet with success at that stage? And we say, of course not. One has to wait for the ultimate resolution by the second instance court for reasons that are pragmatic and common sense. And that is why we are surprised at the change in tune from the Micula parties, because in Statement of Facts, paragraph 35, everybody until the 18th of June had been proceeding on the basis that there was inevitably going to be an appeal, and therefore the first instance phase was not the decisive issue in terms of conflict. And I hesitate to use a rugby analogy at this time, but it's a case of 9-0 at half-time, and there is a second instance of the appellate procedure which has yet to be completed. Now, yesterday Mr. Dimitriou said, well, there's no need to worry about the second appeal because, and I'm quoting her, all that would happen is the award could be enforced, which might result in Romania paying compensation. If down the line the Court of Justice were to reverse the General Court judgment, then at that stage the decision would be valid, the Commission decision. There would be an obligation in Romania to recover those funds. This would not entail any conflict. It is at most a practical inconvenience. And this, with respect, is an extraordinary submission. If it were right, it would mean that it is an answer in every case to say, don't worry about a potential conflict, because if, in the end, the Commission succeeds, it may or may not be possible to unwind the harm in question. We submit that this would make a mockery of sincere cooperation. Sincere cooperation, at its root, is designed to avoid such complications arising in the first place, since to do so jeopardizes the uniform and effective application of EU law. The Micula's formulation with respect is a recipe for chaos and uncertainty. A second point which I've adverted to, sincere cooperation applies on a precautionary basis to ensure conflict avoidance. And if I can just show the Court one authority very quickly, it's the Emerald case, authorities 9, tab 131, and it's at MS 2515. And it's the middle of that page, paragraph 70, and it's about 2/3 of the way down. It starts, it is only where. It is only where, in the words of the Commission delimitus, paragraph 50, there is scarcely any risk of conflict between the decisions of domestic and EU institutions that national authorities should proceed. Where the EU and domestic authorities have overlapping jurisdictions, i.e. considering the same or similar matters, the risk of conflicting decisions will be high. And I made the point yesterday that no one has suggested or could fairly suggest that the Commission's appeal does not have a realistic prospect of success. A third principle on sincere cooperation, this is bolstered in our submission by a further principle of EU law, which is effectiveness, and there is a procedural dimension to the principle of effectiveness. And if I can quickly show the Court one authority, authorities 7, tab 96, it's MS 1785, paragraph 33.
What's this authority?
It's a preliminary ruling request in a case called Kern-Kraft-Werke.
Sorry, I didn't hear that. What's the name of the case?
It's Kern-Kraft-Werke. So you see the title 1777. And it's paragraph 31 at MS 1785. I mean, this will be a very familiar principle to the Court, so I can take it pretty quickly. Any provision of a national legal system, including provisions of a constitutional nature, any legislative, administrative, or judicial practice which might impair the effectiveness of EU law by withholding from the national court having jurisdiction to apply such law, the power to do everything necessary at the moment of its application to set aside national legislative provisions which might prevent EU rules from having full force and effect, or incompatible with those requirements, which are the very essence of EU law. And it's the next bit I rely on. This would be the case in the event of a conflict between a provision of EU law and a national law, if the solution of the conflict were to be reserved to an authority with a discretion of its own, other than the court called upon to apply EU law, even if such impediment to the full effectiveness of EU law were only temporary. A fourth interpretive point is a specific duty in the context of international treaties to interpret those treaties insofar as possible to be compatible with any relevant EU law obligation. And this is the Budvar case, authorities 3, tab 42.
Could you always give us the MS number of the beginning of the case first?
Budvar MS 532.
532.
And it's paragraph 169 at MS 627.
Sorry, paragraph?
Sorry, 577, forgive me.
Which paragraph, please?
Sorry, I'm in the wrong tab. It's,
It's 40, in fact, not 42.
well, yes, thank you.
Yeah.
It's, 627, forgive me. So, my lady, it's Budvar, starting at MS 577, and the reference is at MS 627.
Well, the name of the case that begins on 532 is Butenmüller.
7-7 is the start of the case. Budvar. And the quote is 627.
Oh, yes.
Thank you.
And it's the interpretive obligation. So the court says, and I quote,
Paragraph.
169, my lord.
Thank you.
The National Court must ascertain whether a possible incompatibility between the treaty and the bilateral convention can be avoided by interpreting that convention to the extent possible and in compliance with international law in such a way that it is consistent with Canadian law. And we submit that to the extent necessary, it is possible to interpret ICSID and the 1966 Act and the CPO provisions so as to allow case management powers for the courts to manage the process of enforcement, certainly temporarily, pending the ruling of the Court of Justice. And one can do so in a way that does not do violence to the wording of the provisions. And indeed, we say, particularly based on the CPO provisions, that the interpretation contended for by the Micula parties involves ignoring clear wording of the CPO on the general power to stay. A fifth and final point on...
And does that statement about bilateral conventions also apply to multilateral ones?
Lady, yes. I will come to the Article 351 point in a minute, but in principle, the duty to interpret would apply equally to a multilateral or bilateral treaty. And the fifth and final point I wanted to raise is we also say it is not without significance that the Micula parties no longer pursue their res judicata point in the context of the stay. And we say at the very least, it means that it cannot now be said that a stay would be contrary to the respect for principles of res judicata under EU law. And this further supports the notion that what is at issue here is simply the duty of a national court to offer, in this case, a temporary procedural remedy. Now, to pick up on a question raised by Lord Reid yesterday, It is true the Commission did appear before the ICSID tribunal, but the first point I wish to make is that the Micula parties did have a res judicata ground of appeal that has been abandoned. So we said it isn't open to them at this stage to say the Commission appeared and therefore should be shut out as a matter of res judicata. But the critical point, which is the answer to Lord Reed's question, is the ICSID tribunal in the award expressly found that the enforcement of the award at a national level was not a matter for it. If we can very quickly look at this, because it's quite important. It's in core bundle 2A. It's MS 4900. Paragraph 340 of the award, MS 4900. The ICSID tribunal says, and I quote, "The tribunal finds that it is not desirable to embark on predictions as to the possible conduct of various persons and authorities after the award has been rendered, especially but not exclusively when it comes to enforcement matters. It is thus inappropriate for the tribunal to base its decisions, in this case, on matters of EU law that may come to apply after the award has been rendered. It will thus not address the parties in the Commission's arguments on the enforceability of the award." Moving on to ground 2 of the cross appeal, the essential point made by the Micula parties is, well, if one can have a stay as a matter of principle, one shouldn't have a stay that is too long. And there are a number of very short responses to that submission. We say, at its most basic, if there is a power to stay as a matter of domestic law interpreted in line with ICSID and EU law, then one cannot then complain about the length of the stay that is mandated as a result of the application of the principle of sincere cooperation. To put it another way, if sincere cooperation requires the national court to wait, for example, until the Court of Justice judgment is handed down, it cannot then be said that, well, if the judgment took 6 months, that would be fine, but if it took 12 months, we could ignore sincere cooperation. I mean, either there is a basis for sincere cooperation being engaged, or there is not. And if the delay is inherent in the appeal in question, that goes hand in glove with the application of sincere cooperation to begin with.
You accept that the obligation of sincere cooperation is mutual. It's not unilateral.
Yes, it applies both horizontally and vertically.
And you refer to the 13.4 months. But were the CJEU to agree with the Commission's view, there would then arise an Article 351 point back at the General Court, and then going up to the CJEU, perhaps.
That is a possibility, I accept that.
Yes. So we're not really talking about 13.4 months.
Well, my Lord, in my submission, all the National Court can do is take this in bite-sized chunks. And there is a distinct possibility the decision may vanish in a year's time. And if that happens, so be it. The case will then look very different. There is, of course, the distinct possibility that the decision is upheld, and then there would be a remittal, and that will lead to further delay. I accept that.
But I just wanted to set ground 2 in context, because it is a mutual obligation, and the Commission itself is under an obligation, I take it, to assist the court to achieve justice in the circumstances. Yeah.
As the appeal is presently constituted, the Article 351 point will not arise before the Court of Justice, will it?
That is true. 2 points, if I may. First of all, it is always open to this court, and indeed, this is what Masterfood says. If the court is concerned about delay and uncertainty, the answer is a preliminary reference. That is the court's facility for breaking the logjam. The other point, I mean, it was suggested by Mr. Dimitriou that it was open to the Commission to ask the court to decide all of the other points. No authority has been provided for that proposition. I personally, in 25 years of doing this, have never seen a case of that kind. My unerring experience with the Court of Justice, like any court, is that they don't wish to decide more than they need to. They are extremely strict on things like ultra petita. So that seems to me a surprising point. But certainly from Romania's perspective, I mean, we're not involved in the appeal. We would have absolutely no objection to the Commission or indeed the Micula parties asking the Court of Justice to enlarge its proceeding to deal with all of this in one go. I mean, we have, insofar as possible, done all we can to avoid delay. We cooperated with the Micula parties to bring this case back before this court as quickly as we possibly could. We did not wish to take advantage of any temporary lack of jurisdiction of this court. As I said yesterday, 3 years ago, we proposed a preliminary ruling that would have resolved many, if not most, of these issues, and it was strongly resisted by the Micula parties. So I entirely accept that there is an unattractive vista whereby the decision is upheld, there is then a remittal, and possibly a further appeal, but that is the system. And if I can just show Lord Hodge one point on delay. I mean, I entirely accept that sincere cooperation is horizontal and vertical, and that it is a two-way street. There has to be mutual respect and cooperation. But can I just show the court one point in the Emerald case in Clause 9? So it's tab 131, MS 2516. And it's paragraph 73. So the case starts at MS 2486, and the paragraph is at 2516. It's the bottom of that page. So the first instance judge, his primary reason appears to have been that because he regarded the Commission as having behaved in a wholly uncooperative fashion, there was no corresponding obligation on the English court to cooperate. That, in our view, was a misguided approach. Delay by the Commission, even unconscionable delay, the production of a provisional non-confidential decision, does not relieve the English court of its mutual cooperation obligations under Article 4.3. Now, no one is suggesting that in this case there has been or would be any unconscionable delay by anyone. I entirely accept Lord Hodge's point that the Commission and the Micula parties could perhaps intercede and ask the Court of Justice whether it's willing to enlarge its proceedings. We would have, to the extent it matters, absolutely no objection to that. I mean, the one point I would note is if one looks at some of the Micula's pleas before the General Court, they do concern factual matters that have not yet been determined or reviewed, and which may not be easily resolved by the Court of Justice at the second instance of appeal. So, for example, in one of the appeals, there is a seventh plea which concerns whether the Micula parties are a single undertaking for purposes of state aid law, and there are various factual intricacies surrounding the status of the companies and their management, which have not yet been determined by the General Court. So I entirely take the point there is, if the Court of Justice were willing, there is probably more it could do, but I don't think it is the case that they could resolve each and every aspect of the General Court appeals because of the nature of the pleas in question. With the court's permission, I'm now going to move to ground 4. I will come back to ground 3 at the end. And I want to take this in 2 stages, if I may. First, I want to deal with the specific point about intra-community relations under Article 351 and the rights of third parties under international agreements and how these concepts have been interpreted by the European courts. And second, I want to respond to a number of points Ms. Dumitriou made yesterday on the extent to which the EU courts are competent to rule on international agreements in the context of applying European law. So starting with the first point, in our written case, we gave a large number of examples of an unanimous view in the EU court's case law that the provisions of an anterior treaty cannot be invoked in relations between member states inter se, even if the treaties concerned have non-member states among their parties. And just to give the court the references, it is Commission in Italy, authorities 457. If we can quickly turn that up, just because this is the first case in which the court considered what is now Article 351, and its approach is interesting. So there's authorities 457. And it starts at MS 906. So it concerns the GATT agreement from 1929 and the impact that had on customs duties as between member states. And the part I want to pick up on is on MS 915. It's about halfway down.
915.
My lord, yes. It says the defendant, which in this case was Italy, raises an objection based on 2341, which is now 3511, relating to the maintenance and rights and obligations arising from prior agreements. And then you'll see a reference to the GATT agreement. Then the applicant, which was the Commission in that case, replies that the terms rights and obligations in Article 234 refer, as regards the rights, to the rights of third countries, and as regards the obligations, to the obligations of member states, that by virtue of the principles of international law, by assuming a new obligation, which is incompatible with the rights held under a prior treaty, a state ipso facto gives up the exercise of these rights to the extent necessary for the performance of its new obligations. And the court's response, the applicant's interpretation is well-founded, and the objection raised by the defence must be dismissed. In fact, in matters governed by the EEC treaty, that treaty takes precedence over agreements concluded between member states before its entry into force, including agreements made within the framework of GATT. And essentially, this is the daddy of the Article 351 case law. And this principle concerning intra-community relations has been repeated on a very large number of occasions by the Court of Justice in subsequent cases. Let me just give the Court one further reference, and then I'll give you the rest of the references. It's in the same bundle. Commissioner Luxembourg, Authorities 4, tab 59. So it starts at MS 923, and it's MS 934, paragraph 40. The Court observes that it is settled case law that whilst the first paragraph Article 234 allows a member state to honour obligations owed to non-member states under international agreements preceding the treaty. It does not authorize them to exercise rights under such agreements in intra-community relations. And interestingly, you will see a reference to Commission in Italy, which we've just seen, and there is also reference to the Levy case, which is the leading case relied upon by the Micula parties, and Levy is considered to be entirely consistent with the intra-community relations formulation that the court has said is settled law. Now, it follows, if the Micula parties are correct in their submission, that a general interest of a non-member state in enforcement or compliance with ICSID is sufficient to engage Article 3511, that all of these cases that we've just seen must have been wrongly decided.
Doesn't it depend on the effect of the treaty in question?
Well, my lord, one can look at this the other way around, which is, apart from Levy, which seems to concern erga omnes issues such as human rights and labor conditions, in each and every case involving a multilateral treaty with non-member states and member states, the court has said, insofar as concerns relations between the member states, they cannot rely, inter se, on the obligations under the treaty. In other words, the triangular relationship between the member states is paramount, and the multilateral treaty involving non-member states cedes to that extent.
I understand that, but there must be a question in each case whether the particular obligation is only owed to the other member states, or whether it's owed to the other non-member states as well, so that the intra-community effect can be considered in isolation.
Well, my lord, certainly the existence of an obligation under a multilateral treaty is necessary. That's the first stage. But we then say there is a second stage, which is, notwithstanding the existence of that obligation, as a matter of that treaty, in the context of relations between member states, for example, concerning a fundamental freedom such as free movement of goods, can those obligations essentially trump the obligations under the treaty? And my essential submission is that in a whole series of cases, including two more we will go to now, the court has said no. And it may seem like a curious type of conflict resolution, but it is undeniably the case that the court's application of the Article 3511 case law has, in each and every instance, with the possible exception of erga omnes treaties, resulted in the community obligations being paramount. So there is a conflict resolution, but it is done, at least in the context of intra-community relations, in a particular way.
I can understand that in certain circumstances, it would be open for a group of states parties to a multilateral convention to vary that convention so that it has a particular application in relation to them. But whether in so doing they would be in breach of their obligations to the other contracting states will depend on the content of the treaty. But so it may be that we need to look at the particular subject matter of each of these cases rather than to take the general proposition.
So your Lordship is quite right. Let me pick up two of the cases which we've mentioned in particular. The first is the McGill case, which is in Authorities 7. It's tab 113, MS 2048. So the case concerned compulsory licensing under competition law of a dominant firm's copyright to its rivals. And the Article 351 issue in that case concerned the Berne Convention, and the broadcaster subject to the compulsory license said that the Commission decision was incompatible with Article 9 of the Convention. And what Article 9 provided for, and I quote, authors of literary and artistic works protected by this convention shall have the exclusive right of authorizing the reproduction of these works in any manner or form. So there was the exclusive right in copyright. And then Article 9.2, it shall be a matter for legislation in the countries of the Union to permit reproduction of such works in certain special cases. So the essential point made by the broadcasters who own the copyright was that if their copyright was to be subject to compulsory license, that was first contrary to their exclusive right under the convention, and second, had to be achieved by way of legislation rather than by administrative decision of the European Commission. And we say, given the nature of the rights at issue, the Commission decision in that case involving compulsory licensing necessarily affected all other third country contracting parties, since, given the Commission decision, there was a risk that copyright rights of their nationals would be undermined by the EU in member states applying EU law to require compulsory licenses. And second, contrary to what Article 9.2 of the Berne Convention required, there was no EU legislation bringing about the result in question. So in other words, compulsory licensing via competition law under EU law was a real risk or threat to all copyrights arising under national laws, including in particular those of non-member states. But if one looks then at paragraph 84, so MS 2072, it says, so far as UK and Ireland are concerned, it is true they were already parties to the convention when they acceded to the community, that Article 234 therefore applies to that convention in accordance with the Act of Accession. And again, we see the same formulation again and again, including a reference to another case I will come to. It says, however, settle law, the provisions of an agreement concluded prior to the entry into force of the treaty, prior to accession, cannot be relied on in intra-community relations if, as in the present case, the rights of non-member countries are not involved. And there's a cross-reference to a case we're about to come to. Now, there was a suggestion by Mr. Micula yesterday that the critical distinction between this McGill case and ICSID is that the Berne Convention did not have a dispute resolution complaint procedure equivalent to Article 64 of ICSID. That is incorrect. Can I just hand up the text of the Berne Convention on the dispute resolution clause?
Sorry to rise, just to say that I didn't make that submission yesterday, so I have no difficulty with Mr. O'Donoghue dealing with it, but it's not a submission I made.
That's fair. But well, the court can see from Article 33, under the Berne Convention, there was scope, as under ICSID, to bring proceedings before the ICJ. So from that perspective, there doesn't seem to be any relevant distinction between ICSID and the Berne Convention.
Can I see if I'm following this? This convention obviously was to do with the interests of countries, and so there's provision, as you've just shown us, for the resolution of disputes between countries as to how the convention should be interpreted or applied. In the present case, how do you say one determines whether the interests of member states or non-member states are engaged?
Well,
Under ICSID.
Well, in my submission, one needs to distinguish between an abstract interest in enforcement of ICSID awards and a concrete interest of the nationals of a contracting party in the enforcement of their award in an ICSID signatory.
So if the individual involved is a company, it's a crucial question, in what jurisdiction is it registered?
Well, yes, the nationality of a claim.
Or where does it have its commi? Or where are its shareholders?
Well, we say in this case the situation is very clear. The Micula parties are Swedish nationals. The award is rendered against Romania, a member state, and the United Kingdom, another member state, is being asked to enforce. So in terms of the relevant obligations in concrete terms, we say it is all intra-community. And we further say that the abstract desire of non-EU member states to have ICSID awards in general enforced all around the world is not sufficient in terms of its concrete nature to amount to a relevant interest or a relevant obligation.
So the test is what? Place of the country where you are incorporated, or your commi, or where your shareholders are, or what?
Well, for the private persons, it is their nationality. For the companies, it is their domicile.
I think it suggested, Mr. O'Donoghue, that in this case, the interests of those non-member states in whose jurisdictions there may be attempts to enforce the ICSID award would be engaged.
So
For example, the United States.
Well, we don't understand that submission because the award has been enforced in the United States through the judgment Lord Reid referred to yesterday.
But the question here would be whether the subset of the operation of the convention in a varied form in relation to the subset of states who are members of the European Union has such an effect on the interests of a state like the United States, where there's an attempt to enforce, so as to amount to a breach of the convention as against them.
Well, Lord, at the risk of repeating myself, we do say that one needs to focus on each concrete claim and the nationality or domicile of the enforcing parties or countries, and not on an abstract interest of non-member states.
But I mean, it's not completely abstract, because states, non-member states, can see that if the award's not going to be enforced in member states, the risk, and it may be a very real risk, as my lady says, it's happened in the US, that efforts be made to enforce in their jurisdictions goes up.
Well, that submission was made yesterday, that the inconvenience of enforcement taking place in a non-member state as opposed to a member state gave rise to relevant interest. And we don't accept that. I mean, in principle, one can choose to enforce in a range of jurisdictions. And in our submission, it can't be said that the mere fact that there would be some added enforcement in one jurisdiction as opposed to another is sufficient to give rise to a violation of somebody's interests under ICSID. That is the choice of the enforcing party in each case.
the point I was putting to you is that their choice is going to be conditioned. If they can't do it in European member states, they're going to be forced to go to other states, for instance, the US. And therefore, there is, or arguably, an engagement of the rights of those other states, which would flow from what you say is the effect of the EU treaties as between member states.
Well, perhaps, but we say the questions are sequential. The first question is there a relevant interest? And then the second question, assuming that that is answered in the affirmative, is does that relevant interest apply in the context of intra-community relations? So these are sequential questions. So if I'm wrong on the first question, the second question remains essential to answer. And I do say that based on the case law we've seen, it is extremely clear that in a triangular relationship such as at issue in this case between Sweden, Romania, and the United Kingdom, only intra-community relations are involved and therefore prevail to the extent necessary over ICSID.
So the implication would be that if say, a private investor in the United States is thinking of investing in Europe and wants to preserve its rights under ICSID, then it can't channel its investment through a vehicle based in Ireland, for example, or Luxembourg, but has to invest directly or via a vehicle based outside the EU.
Well, that certainly would be the safe option, as it were. But, I mean, I do come back to the point that there is no fundamental difference between the nature of the rights and interests, as we saw in the Berne Convention under Article 9, and what is being suggested in this case. The signatories of the Berne Convention had at least the same interest as ICSID parties in ensuring that the copyrights protected under their national property laws for the benefits of individuals and companies were respected all around the world, and that if there was to be compulsory licensing, that could only be done through legislative means and not by administrative decision-making. So we do ask rhetorically, if Article 351 was not satisfied in the context of the Berne Convention obligations, how is that distinguishable in any way from the interest said to be at issue in this case? If I could just show the court a second case, which is the De Zerbe case in Authorities 5. It's in tab 73. It starts at MS 1247, and as you'll see in the middle of the page, it concerns the International Convention on the use of designations of origin and names for cheeses. And then over the page at MS 1248, 1249, so the background to the case was that French law restricted the right to use certain cheese names, for cheeses with a minimum fat content, and refused to allow Edam cheese, marketed lawfully in Germany, to be marketed under this name in France, relying on the International Cheese Convention. You can see that from paragraphs 4 and 5 in particular. And the way that the convention worked was that each interested country in a particular cheese would put forward the denomination, and in this case, as I said, the fat content. So the Netherlands put forward Edam with a particular fat content, and thus it is the interested country which defines the required characteristics, and that has the right to see those standards enforced under the Convention. So to recap, EDAM was denominated by the Netherlands, so France was upholding the Netherlands' right to see that EDAM was only sold when it met the fat content requirements specified by the Netherlands, which the German EDAM did not. Now, 2 points emerge in our submission clearly from the judgment, starting at MS 1252. So the court will see at 16, so the convention was a pre-accession treaty, and only some member states were parties to it, and quite a number of non-member states were also contracting parties, including, for example, Austria. '17, in accordance with principles of international law, the application of the treaty does not affect the duty of member states concerned to respect the rights of non-member countries under a prior agreement to perform its obligations. And consequently, provided that is in the present case, the rights of non-member countries are not involved, member state cannot rely on provisions of a pre-existing convention of that kind to justify restrictions on the marketing of products coming from another member state where the marketing thereof is lawful by virtue of free movement of goods provided for by the treaty. And that comes back to my point in inter-community relations. So the point is that in a triangular relationship between, in this case, France, Germany, and Netherlands, one could not rely on a pre-existing treaty to defeat the free movement of goods between member states. And that is what we mean by intra-community relations. So again, as a matter of application of Article 3511, the Court of Justice has consistently said that where a fundamental freedom is at stake, as between member states, even if non-member states are implicated, the earlier treaty does not have priority.
But in this case, when, for example, the United States and France, say, entered into ICSID, the United States was agreeing that French companies could invest in the United States and benefit from the arbitration facilities and enforcement and so forth laid down in the convention. And equally, the United States was envisaging and was entitled to expect that its nationals would be able to do the same in France. But the implication of what you're saying is that they can't if their nationals invest through subsidiaries based in European countries, which would be the ordinary way in which they would make an investment.
Well, in my submission, well, 2 points. First of all, the relevant community interest in this case, which is engaged, subject, of course, to the ultimate validity of the Commission decision, is that all member states have a right to insist that unlawful state aid is not paid out by Romania to certain beneficiaries. And that is a fundamental right under the treaty, again, assuming the Commission decision is upheld. And the case law I've shown the court absolutely consistently has said, in the context of that intra-community relation between Romania, Sweden, and the United Kingdom, the prohibition on unlawful state aid has to be upheld. And that is so even if, in some sense, non-member states, in this case under ICSID, have certain interests in the enforcement of arbitral awards. That is the way in which conflicts are resolved, rightly or wrongly, under Article 3511. And indeed, as I showed the court, from the very outset in Commission versus Italy, the very first case in Article 3511, that is what the court has said. And it has said that consistently since then. And to pick up on a point made by my Lord Lloyd Jones yesterday, I mean, in treaty terms, of course, this is a somewhat curious thing, but it may, rightly or wrongly, be a manifestation of some form of lex posterior. In joining a new legal order in the community, the member states have, at least among themselves, in relation to fundamental freedoms, agreed to a resolution of treaty conflict in a particular way that involves, again, rightly or wrongly, some deference to those fundamental rights under EU law.
I think that may be what the court was saying in paragraph 40 of Commission against Luxembourg, to which you've already referred us. But perhaps the critical point here is paragraph 84 of RTE and the words, if the rights of non-member countries are not involved.
Yes. So, again, my submission is, given that the designating country in this case, for this convention, had a right to insist that its particular formulation or requirements for cheese would be respected all around the world by the signatories, those rights are no different to the rights which are said to be at issue in this case. So we have the Berne Convention, which in my submission is indistinguishable, where the court said Article 511 does not apply. We have the second case concerning another convention where the designating countries had very similar rights and very direct rights, and again, Article 3511 does not apply. And so there is a pretty consistent line of authority that the mere existence of a certain right is necessary but not sufficient. And if I can pick this up in the Court of Appeal judgment, so we do say there are two questions. One, of course, there has to be a relevant obligation under the international treaty. So that's question one. And then the second question is, even assuming that obligation in some sense exists, is the principle of intra-community relations engaged? And if I can give the court two references to the Court of Appeal judgment on this point. So it's a core volume appendix 1. It's 4673.
Could I have the paragraph number, please?
Yes, it's paragraph 156 and following. So this is Lord Justice Hamblin. So it starts at 156. So he tees up the central Article 351 issue in the General Court proceedings. Then he sets out essentially all of the cases we've looked at. 159, present proceedings involve nationals of Sweden, asking the courts of another member state of the UK to give effect to obligations it owes under the UKSC Convention to enforce rights Sweden possesses against another member state, Romania. There's no direct involvement of any EU or third country. However, it is said that the rights of such countries are involved, as they're all parties to ICSID. They have an interest in its effectiveness, and so on. And the last sentence is the critical point, which is my submission. Even if such a claim could in principle be brought, whether that would mean that this case is not one involving intra-community relations is also in dispute in these proceedings and those before the General Court, and is an EU law matter. And a second reference at MS 4679, Lady Justice Arden. Paragraph 188. But 2/3 of the way down, of course, the question whether that, so the interest in ICSID enforcement, would be sufficient for EU law purposes would be a matter of EU law, and then she expresses a provisional view. So that is why we say that there are two separate questions. And picking up on the point of conflict, one of the reasons for my discomfort in some of these issues is that all of these very points are at issue in the pleadings in the cases in Luxembourg. If I can just quickly give the court one reference. It's at 42A. MS 5424. Sorry. 5424. It's 2A's. It's a commission rejoinder. Sorry, forgive me. It is 2B. 54. Is it 2B?
What
It
are we,
is-
look,
it-
what
it
are we
is
looking for?
5424.
What are we looking for?
This is the commission rejoinder. So it's the commission's pleading in one of the appeals before the European courts, and it's, so my lady, it starts 5402. So it's a rejoinder in one of the appeals by the commission, so it's responding to the Micula's own pleadings. And if we can go back to 5424. I won't read this, but it starts at paragraph 79 and continues over the page. And essentially what the court will see there is a rehearsal of the very argument we're having now and a discussion of all of the cases that I have shown the court. So, for example, you'll see at 81 over the page. So this is what the Commission is arguing. The CJU has further recognised that even where a pre-accession treaty is a multilateral treaty, it does not engage Article 351 insofar as relation between member states is concerned. And there's a reference to Commission in Italy, which we've just seen. And 83, the McGill case, which we've also just seen. So, again, we do say that in terms of conflict, it is relevant to note that these very points, subject to the question of remittal, are before the European courts. And
maybe before the European Court, depending on the outcome for the CJEU.
yes, yes.
And that, we won't know that for 13 and a half months anyway.
That is fair. But, I mean, one way to think of conflict is to ask oneself the following. Suppose it was the case that a national court, whether this national court or any other national court, decided the Article 351 issue today and said, well, we have reached the view that Article 3511 is engaged and therefore EU law does not apply at all to the advantages received under the award by the Miculas. Now, then suppose that the Commission decision is vindicated and the European courts rule on the Article 3511 issues, and they reach the opposite conclusion, that in fact Article 3511 does not apply. And in terms of conflict, we say that that is a clear problem under sincere cooperation, because in principle in any one of the 28 member states, there are parallel litigations in other member states, as you know. If in principle any national court can reach an individual conclusion on the application of Article 3511 in this case, the effect of that conclusion is essentially to render the appeals before the courts in Luxembourg pointless. Because if it is the case, according to a national decision, that Article 3511 is engaged, then it doesn't matter what the decision says. The appeals in Luxembourg would become utterly pointless and of no practical value. And that is why I've shown the court why, subject to the contingency Lord Hodge fairly raises, that with the European courts being realistically seized of the same points, there is a conflict risk under sincere cooperation of different national courts reaching different conclusions on the application of Article 351.
A particular point with which we've been engaged for the last 20 minutes or so is essentially a point of the interpretation of the multilateral convention concerned, isn't it?
Well, that is certainly part of it. I entirely accept that. But the court has my point, which we've seen in the pleadings in Luxembourg, that, at least according to the Commission, that is not the end of it. There is a second question of intra-community relations and whether that operates, in effect, to require the member states, insofar as concerns fundamental freedoms, at least inter se, to respect the obligations under the state aid provisions. So that is the argument. I mean, in a sense, it doesn't matter at this stage whether the Commission is right or wrong on that point. The point is that argument, at least on one contingency, is something which is before the courts in Luxembourg. And when one thinks about this in terms of conflict terms, there is a substantial, certainly realistic, prospect of seriously conflicting judgments on this issue at a national level.
It might be said that you only get on to that second question, which you identify, if the rights of non-member countries are not involved under the multilateral convention.
Well, that is the very debate, as we've seen in the pleadings, that there is a divergence of views between the Micula parties and the Commission. I have made submissions along the lines that I have, that there is a second question, but ultimately whether I'm right or wrong, the conflict point is that is an issue which realistically may come before the European courts in these appeal proceedings, and that realistic possibility is a reason at this stage why 28 different national courts in different member states should not be deciding this question in different ways. And I repeat the point that one can see the practical consequence of this, because if a national court decides today that 3511 is engaged, then the decision isn't worth the paper it's written on. There is then no point to the appeals in Luxembourg, because enforcement will be permitted in full in one or more countries. And that, in terms of sincere cooperation, in my submission, that is the critical point.
There would still be a point for a Luxembourg ruling, because even if enforcement were permitted, Romania would be under an obligation if the CJEU were to rule otherwise to recover the funds if it were to be held by that court that the member state intra-community obligations took precedence over ICSID.
Well, that is certainly true, but as I said earlier,
So one cannot say that there would be no point in having a Luxembourg ruling. Just the Luxembourg ruling would be too late to prevent enforcement, but it might require recovery.
well, yes, in that scenario, the horse would have bolted, and there would be a practical question as to whether some or all of the monies concerned could be recovered. But I do repeat the point that the way sincere cooperation objectively is intended to work is not that you try and unscramble the omelette at a later stage, is that one prevents or minimises the scope for conflict at the outset by applying a precautionary approach. Because in every case, one can say, well, don't worry, because ultimately the member state could be sanctioned, the money could be subject to a recovery decision, the member state could be subject to infringement proceedings, we have to pay pecuniary penalties, but that after the fact sanction or remedy is, with respect, not an answer to the principle of sincere cooperation, which requires engagement at this stage and not the unscrambling of the omelette when the damage is done. Now, can I turn quickly to responding to a number of submissions made by Ms. Dimitriou yesterday. First, she referred to the Korean case, which is in Authorities 9, tab 137. She took the court, so my lady, it's MS, starts at MS 2747. And the paragraph I'm interested in is from Lord Bingham at 2755. So Ms. Dimitriou took you to Lord Hoffman's speech. And can I ask the court to look at paragraph 11 from Lord Bingham? It says, second sentence, community law prohibits the making by national courts of decisions which contradict decisions of the community institutions on the same subject matter between the same parties, and strongly discourages the making by national courts of decisions which may be inconsistent with decisions which may yet be made by the community institutions on the same subject matter between the same parties. But it does not, on the analysis Lord Hoffman, go to the length of requiring national courts to accept the factual basis of a decision reached by the community institutions when considering an issue arising between different parties in respect of a different subject matter. And the suggestion made by Ms. Dimitriou was that we were in Lord Hoffman territory and not in the scenario envisaged by Lord Bingham. But we say we're clearly not in the Lord Hoffman scenario. This does not concern factual findings involving different parties and a different subject matter. It is a legal question to do with the same parties on the same subject matter. And on that basis, Lord Bingham is very clear. The duty to avoid conflict and to engage with sincere cooperation is plain. Now, the second point she made was the judgment of the European courts on the international treaty conflicts issues, subject to the Commission decision being upheld, wouldn't in any event be binding on this court. She suggested for two reasons. First, that was simply a finding of fact which would not bind this court. And second, the European courts would be considering the situation of Romania and its obligations, and not the obligations of the United Kingdom under ICSID. Now, we've picked up these points in some detail in our written case, and can I just quickly show you the relevant passages? So it's in core 6. It's MS 440. Four four zero. 4440. So you will see 142 to 14.
And this is what?
Well, this is our written case for this court. So just to run very quickly through this. So we've set out a 143 to 145, all of the overlaps between the 351 issues before this court and the issues being ventilated in Luxembourg. And for example, if one sees at 143, you will see the argument in the underlying text that the ICSID obligations are said to concern all contracting parties and the question of interest of those parties. And then 144, the argument in the other direction from the Commission, which essentially concerns the intra-community relations point, and so on. And in relation to the argument that there is a material distinction between Romania and the United Kingdom, we pick this up at 4445, 151b. We say, bottom of the page, distinction without a difference, and over the page, like the UK, Romania also became a party to ICSID before it acceded to the EU. Two, an important point. Claimant's case that each state party has an interest in performance in exactly the same way to the obligations owed under Article 53 as it does the obligations owed under Article 54. As is clear from the extracts cited above, which we've seen, the claimants rely directly upon Article 54 before the General Court and make the same arguments that they make before this court. And it is notable the claimants do not seek to draw this distinction until late in their case, dealing with overlap, but do not explain at this stage how this can be reconciled with the earlier part of their case on the question of to whom the obligations are owed. And final point, I mean, the court will see from 142 to 14 to 150, I mean, all of the cases we discuss are essentially the cases which are being ventilated in the pleadings in Luxembourg. So the overlap, we say, is direct and more or less complete. And there is no relevant difference in conflict terms between the obligations of the United Kingdom and those of Romania from this perspective. Now, turning finally on the cross appeal to ground 3, take this very briskly. So Mr. Green's argument, as I understand it, is that Parliament did not intend to put the United Kingdom in breach of ICSID, for example, by permitting a stay. And he says that that goes against the grain of ICSID. And in particular, he says that it should not affect pre-accession obligations. So that is his 1972 Act argument. But we say, in essence, the argument under the 1972 Act simply collapses into the Article 351 point. And it is a very simple submission. Article 351 is the treaty conflict resolution provision of the European treaties. In enacting the 1972 Act, the United Kingdom also enacted Article 351, and in so doing, by virtue of the principle of conferral, they conferred the treaty conflict resolution principles to be decided on the basis of Article 351 of the treaty. And to put it another way, having made that conferral under Article 351, there isn't then a second bite under the 1972 Act, which would allow the United Kingdom to say, well, notwithstanding Article 351, one can separately and entirely outside the confines of Article 351 divine an intention on the part of the United Kingdom not to make a particular treaty, in this case ICSID, subject to the Article 351 set of principles. And we say that this would be an unworkable submission, because it would mean in each and every case one would have to ask oneself, well, did the United Kingdom in 1972 specifically intend that this particular treaty would fall inside or outside the conflict resolution principles in Article 351? And we say that in adopting the treaties and enacting the 1972 Act, it is plain that the United Kingdom conferred the resolution of conflicts between treaties on the interpretation and application of Article 351. So we say that there is no separate domestic constitutional point. I mean, to be clear, we entirely accept the principles of conferral. We entirely accept there is no competence, but my submission is that the resolution of treaty conflict in Article 351 that has been conferred through the 1972 Act and reduced to the principles under Article 3. So I wasn't proposing to say much more than that, unless the court has further questions. Turning now to Romania's appeal, which is the security question. Can I start with a couple of contextual remarks, if I may? We submit that it is obvious and clear that the Commission was aware of a significant national dimension to the enforcement of the award. And we can pick this up in the Commission decision itself at core volume Appendix 1, MS 4764. This is the Commission decision. And if one looks, for example, at MS 4769 to 70, paragraph 31. So there the Commission notes enforcement at a national level and then at 38, enforcement in the United States. So the Commission was clearly aware of national litigations and enforcement. And then at MS 4791, the operative part of the decision, Article 4.2, Romania should keep the Commission informed of the progress of national measures taken to implement this decision, and so on. Commission clearly expected to be kept informed by Romania of any and all national attempts to enforce the award in the decision. And then in its pleadings in Luxembourg, if we can turn quickly to 2A. It's 5263. So this is the Commission's defence in one of the appeals in Luxembourg, and it's paragraph 211.
I'm sorry, which was the page again?
Well, it's MS 5263. So the Commission says, as regards any payments made under the award of which the Commission was unaware and any future payments, the Commission recalls the award subject of recognition and enforcement proceedings in the world over. The Commission is usually informed of these proceedings at a very late stage and not at all. To ensure that payments made as a result of such proceedings did not escape recovery, Recital 161 of the contested decision includes any payments of which the Commission was not aware or any future payments made under the award. Now, the reason why the Commission, of course, wished to be kept informed and wished to make provision for subsequent payments in the decision was that there are practical implications and concerns. The Commission found that the payments and advantages to the Micula parties gave them advantages over competing undertakings affecting trade in the EU. If we can pick up the decision in the core bundle again, in Appendix 1, MS 4784. Paragraph 1, 2, 3. So the second sentence, the Commission has also concluded the payment of the compensation claimants would improve their competitive position as regards other undertakings with which they compete who have not received similar compensation for the withdrawal of the unlawful state aid, and so on. And last two sentences, a liberalised market exists for all these products, so any advantage granted to the claimants is liable to distort competition. Considering that the products primarily produced claimants are widely traded between member states, it is clear that any advantage granted to the claimants is also liable to affect trade between member states. Now, the claimants, of course, say, which is fair, that they made investments in Romania, but there is another side of the coin, which is if the Commission decision is ultimately correct, then they also received unlawful competitive advantages by the incentives in question, and those disadvantaged other competing undertakings within the European Union. So put another way, the rights of all competing undertakings in the EU, if the decision is correct, have to be protected, and this may of course include UK undertakings. Now, consistent with the operative part of the decision in Article 4.2, as we've just seen, the Commission has intervened in the High Court, the Court of Appeal, and the Supreme Court, which is unprecedented insofar as I am aware. It has also intervened in proceedings in Belgium, Luxembourg, Sweden, and France, and in the United States. And it has been in constant correspondence with Romania on these national proceedings. If I can just hand up one letter which hasn't made its way into the bundle. So this is a letter from Commission to Romania from 2016. And over the page, requires Romania to keep the Commission informed of the status and outcome of national, international, and arbitral proceedings in relation to compliance with the decision. And then the final contextual point we can pick up in the core bundle. In the Commission's written case, which is core bundle MS 4603.
46.
03. This is a summary by the Commission of the proceedings in which it has been involved in other member states. So you will see in 16 in Belgium, there was an initial charge or lien on bank accounts. This was set aside at first instance because it would conflict with the decision. And then, of course, there's a reference to the Belgian preliminary ruling. And then 17, there was an ex parte freezing order obtained from the Luxembourg courts, which was overturned by the Court of Appeal. And last sentence, the Luxembourg Court of Appeal, like the Brussels Court, held that the decision was binding on national courts and prevented the grant of even the security the claimants initially obtained in the form of a freezing order. And then finally, Sweden, which is the state of nationality of the two Micula claimants. The Swedish District Court upheld a decision not to enforce the award in light of the decision, essentially on the grounds that since a Swedish judgment whose enforcement would breach EU law could not be enforced, Article 54 of the ICSID Convention did not require Sweden to enforce the awards, and there is an appeal pending against that. And that point, of course, goes back to the submission I made earlier, which is there is a European dimension to the question of a stay, which it seems the Swedish court, in that case, accepted. So that is by way of context. Now, the security appeal also engages principles of sincere cooperation, but in a slightly different way. And just to pick up on a handful of legal points in this connection, first we say that sincere cooperation is a practical thing at its core. There is an article in Authorities 13, tab 190, MS 4040, where the author says as follows in relation to sincere cooperation. All national authorities, judicial and non-judicial, have to take whatever action is necessary to make the EU legal system work in the way that it is objectively intended to work, and a corresponding duty to avoid any action which would interfere with this working. And this, of course, implies both positive and negative duties. A second point on sincere cooperation, it is obviously context dependent and can give rise to a highly diverse series of applications in practice. We gave examples in our written case of the Zwartfeld case where the Commission was obliged to produce documents for a national non-judicial body and to make Commission officials available for questioning. That is Authorities 8128 MS 2431. And we gave example of the Boiron case where sincere cooperation gave rise to a third-party disclosure obligation in the context of litigation. That is Authorities 797 MS 1796. A third important point, sincere cooperation can be engaged before a final, settled, or even formal position of the EU institutions is involved. A highly relevant example in this context, of course, is the standstill obligation under Article 108.3 of the TFEU. The duty to apply a standstill, not to put the aid into effect, applies even if it turns out in the end that there is no state aid at all involved, or if there is state aid, it is compatible aid. And we gave a series of examples in paragraphs 33 and following of our written case of cases where, first of all, Commission proposals had been issued without decisive final measures. This is the Sea Fisheries case, Authorities 567, MS 1102, and sincere cooperation was engaged in relation to those proposals. We gave examples of where negotiations were initiated at the EU level, and this engaged a duty of restraint, that is the Inland Waterways case, Authorities 451, MS 763. And finally, we gave the example of the Stockholm Convention case, where the formulation of a strategy at a European level, but which had not yet been implemented in concrete terms, was sufficient to engage the principle of sincere cooperation, that is Authorities 564, MS 994. A fourth point, which we've already seen, and I can take very quickly, is of course Master Foods, and we saw from paragraphs 51 and 52 of Master Foods that it applies both to an existing Commission decision or EU institution proceeding and to a contemplated proceeding. So it applies to both. And finally, we also see from De Limitis, if we can turn this up, it's Authorities 5, tab 72, MS 1227, and it's paragraph 47 of the judgment. It's 1242. Says, second sentence, account should here be taken of the risk of national courts taking decisions which conflict with those taken or envisaged by the Commission in the implementation of, in that case, competition law. So those are the general principles in relation to sincere cooperation for the appeal. Can I now turn to the question of the mechanics and procedure of state aid enforcement? This case, of course, as you heard yesterday, is concerned with new state aid as opposed to existing state aid. And if we can turn up the state aid procedural regulation, it's in Authorities 1, tab 4, which is MS 48. So it starts in MS 43. So this is the main procedural regulation for state aid enforcement, Council Regulation 2015. Starting with Article 2.1 on MS 48. Any plans to grant new aid shall be notified to the Commission in sufficient time by the Member State concerned. And then Article 3, which is the equivalent of the standstill, it says aid notifiable pursuant to Article 2.1 shall not be put into effect before the Commission has taken or is deemed to have taken a decision authorising such aid. Then a couple of pages on Article 13, MS 53. These are the interim powers of the Commission to injunct, to suspend or provisionally recover aid. Then you will see under Article 14, non-compliance with those injunction decisions can lead to enforcement proceedings. And there is the possibility, as you will see in Article 14, for the matter to be referred directly to the Court of Justice for declaration. And then over the page to two further points. Article 16, 16.1, the Commission can adopt a recovery decision. 16.1, and then Article 16.3, recovery shall be effected without delay. So these are the basic procedural tools available to the Commission under the state aid regulation. Now, a further important point in the context of these powers, we can pick up in the Open Skies case, which is in Authorities 5. It's tab 65. It starts at MS 1015 and it's MS 1030. So this is the Advocate General Tiziano in this case, and he cites Commission v. Germany. Quotation, given its role, the Commission, as guardian of the treaty, the Commission alone is competent to decide whether it is appropriate to bring proceedings against a member state for failure to fulfill its obligations and to determine the conduct or omission attributable to the member state concerned on the basis of which those proceedings should be brought. So it is within the Commission's exclusive competence to bring infringement proceedings of various kinds. So that is the sort of basic procedural backdrop against which the question of security falls to be considered. Now, in terms of how we say a conflict arises in the present case between the security order and these provisions, I want to take this in the following way. We say that if the security order is ultimately upheld by the national court, there are at least three options which would present in terms of enforcement by the Commission. The first option is that Romania would be obliged to notify the grant of new aid to the Commission, and I can confirm on instructions that if the security is ultimately maintained, Romania will notify the intention to grant security to the Commission, and indeed it would be foolhardy for Romania not to do so. And we saw in Article 2.1 of the Procedure Regulation that there is a requirement imposed on Romania to notify the grant of, or to notify plans to grant or alter aid, and the same obligation is reflected in Article 108.3 TFEU, which says the Commission shall be informed in sufficient time to enable it to submit its comments of any plans to grant or alter aid. If security is ordered and the obligation to notify is activated, then the standstill obligation in Article 108.3 kicks in automatically. If we can quickly look at that, it's in Authorities 1. Tab 3. MS 32. So you will see 108.3, the point I've just mentioned, which there is a procedure regulation, there is an obligation to notify the Commission. And then the last sentence, the member state concerned shall not put its proposed measures into effect until this procedure has resulted in a final decision. Now, in terms of how this, how the standstill in legal terms applies, can we look at Authorities 3, tab 43, please? It starts at MS 631. Tab 43, Authorities 3, MS 631. And I want to start at paragraph 36, which is MS 635. So the Court will see at paragraph 35, there's a reference to what was then Article 88.3 EC, which is now 108.3 TFEU, so the provision we've just seen. And so the Court explains the rationale for this provision. It says the prohibition is designed to ensure that the system of aid cannot become operational before the Commission has had a reasonable period in which to study the proposed measures in detail, and if necessary, initiate the procedure provided for in Article 88.2. 37, Article 108.3 thus institutes prior control of plans to grant new aid. And then 38, important point about the role of national courts. National courts do no more than preserve until the final decision of the Commission the rights of individuals faced with a possible breach by state authorities of the prohibition laid down in Article 108.3. Last sentence, it is indeed important to protect parties affected by the distortion of competition caused by the grant of the unlawful aid. 39, the national courts must in principle allow an application for repayment of the aid paid in breach of Article 108.3. Paragraph 40, an important point, the Commission's final decision does not have the effect of regularising retrospectively implementing measures which were invalid because they had been taken in disregard of the prohibition laid down in that article, which is the standstill. And then 41, the national courts must therefore ensure that all appropriate conclusions will be drawn from the infringement of the standstill obligation according to the national law as regards both the validity of measures giving effect to the aid and the recovery of financial support in disregard of that provision. And then last 2 points, 47 and 48. The last sentence of Article 108.3 is based on a preservative purpose of ensuring that any incompatible aid will never be implemented. That purpose is achieved first provisionally by means of the prohibition, which it lays down, and later definitively by means of the Commission's final decision, which, if negative, precludes for the future implementation of the notified aid plan. So the key point under my first option is that as soon as Romania is obliged to notify the grant of, or plans to grant security to the Commission, the standstill obligation under Article 1083 kicks in automatically by dint of the fact of the Commission having been notified.
And why do you say the grant of security is itself state aid? Because the money doesn't reach the Micula parties.
Well, I will come to that. I mean, there is a rich context here, which I will come to, but I mean, essentially, for the last several years, including before ICSID, the Commission has made consistently clear that it regards the payment of security as aid within the meaning of Article 107. But I will come to that. But, my Lord, in a sense, the point I'm making here is a point about institutional competence and procedure, which is, if Romania has to make this notification, which it will have to out of at least an abundance of caution given the Commission's position, as soon as that notification is made, whether and to what extent the security ultimately is found to constitute aid is neither here nor there. At this stage, the relevant point in terms of institutional competence would be that the standstill would be activated, and that unless and until there is a final Commission decision, the status of security ultimately, as a form of aid, or perhaps as a form of compatible aid, remains at large. And the procedural point is that the notification is without prejudice to whether or not ultimately there is state aid involved, because the Commission could do a number of things. It could find in its final decision this is not aid. It could find it is aid, but it is compatible aid, or it could find that it is aid, but is incompatible. But the procedural point is that the making of the notification and the automatic application of the standstill has a preservative effect on the status quo, and it is then exclusively a matter for the Commission, as a matter of state aid procedural law and institutional competence, to decide whether or not aid is involved. So to put it another way, once the obligation to notify is triggered and the standstill applies, it does not matter that the National Court considers that objectively there is no aid, since it remains open to the Commission, having been notified, to reach the conclusion that there is aid or is not aid. The procedural point of significance, or the point of institutional competence, is that at that stage, once notification has been made and the standstill is triggered, only the Commission can decide the question either way. Now, we can pick this up again in the procedural regulation at Authorities 1. And it's MS 48. Article 4 of the procedural regulation. So these are the steps after notification. So 4.1, the Commission shall examine the notification as soon as it's received and shall take a decision. Where the Commission, after a preliminary examination, finds the notified measure does not constitute aid, it shall record that finding by way of decision. So again, the point of procedural and institutional significance is that when the Commission is notified, it has a suite of decisions which it can take, including, of course, ultimately, that no aid is involved. But the critical point in terms of that institutional competence and the role of national courts is that once the standstill obligation is activated, it is automatic in terms of its consequences that only the Commission can ultimately decide either way whether state aid is involved or not. Sorry, Article 5 or Article 4.5? Has to read 4.5, 4.6, I'm very happy to do. The decisions, paragraphs 2, 3, and 4, shall be taken within 2 months. And then there's it explains how the period is calculated. And where the Commission has not taken a decision within the period in paragraph 5, the aid shall be deemed to have been authorised. So there is a long stop or default. That's perfectly fair. But
and hasn't the Commission known about the security order by the Court of Appeal for a long time now?
Well, yes, but it was immediately suspended first by when the Court of Appeal granted the security order, the Commission wrote to Romania immediately and said you cannot pay this security. We regard it as state aid, and it is incumbent on you to appeal the security order and seek its suspension. What happened was the Court of Appeal immediately suspended its own order pending an application for permission to appeal. And then on the 31st of October last year, the Supreme Court continued the suspension until its judgment and or further order. So, Lord, I think that the practical answer to your question is that because the security never, in fact, was activated, the Commission has not been required to date to take to decide the question. But the point I'm making is that since this is the court of last instance, if the security is ultimately ordered, Romania will have to notify it, and at that stage the Commission will have to take a decision. And the point of institutional competence under the state aid procedure is that that is a decision which can only be taken by the Commission, even if the decision is ultimately that no aid is involved, and unless and until that process has been completed, it is clear from the Self case which we've just seen that the national courts should allow the institutional competence of the Commission to reach its termination. So it's really a procedural point, is what I'm making. So that is the first option. Now, the second option is that even if Romania did not foolishly notify its plans to grant security and sought to pay the security, the Commission can start a new investigation ex officio, and in that context, there may be suspension decisions even before the final Commission decision on the status of security as state aid. And again, if we can go back very quickly to the procedural regulation, Article 13 MS 53, Article 13.1, which can adopt a decision requiring the Member State to suspend any unlawful aid until the Commission has taken a decision.
Sorry, Article?
13.1, my Lord.
13.1.
13.1, MS 53.
Yes, thank you.
The Commission can adopt a decision requiring the Member State to suspend any unlawful aid until the Commission has taken a decision of the compatibility of the aid with the internal market, suspension in junction. And then 13.2, the Commission may adopt a decision requiring the Member State provisionally to recover any unlawful aid until the Commission has taken a decision on the compatibility of the aid with the internal market, recovery and junction. And there are various conditions for that. And then Article 14, which we saw earlier, if the Member State fails to comply with the suspension injunction or recovery injunction, there can be a direct reference to the Court of Justice for a declaration of failure to comply. apply. So we say there is even if Romania foolishly did nothing, there is a second procedural or institutional mechanism whereby the Commission would be fully competent to issue suspension and or recovery decisions in relation to security if plans to pay security were made aware to the Commission. The third option, which is an option the Commission has adverted to in its written case, is that the Commission considers that security could fall within the terms of the existing suspension injunction and or the separate decision to open proceedings in the Micula case. And Mr. Khan, I think, will deal with this in more detail, but he makes the point that neither decision has been annulled. They are therefore extant, and the Commission can rely on them. And if we go back to the procedural regulation, Article 28, MS 58, deals with non-compliance with decisions and judgments, where the member state concerned does not comply with a conditional or negative decision. In particular, it cross-refers to Article 16, recovery. The Commission may refer the matter to the Court of Justice, according to Article 108(2). And then, if the member state concerned has not complied with the judgment of the Court of Justice, there can be an application for pecuniary penalties. And on the topic of recovery, the defences available to member states for non-recovery are in practice vanishingly thin. We can have a look at Commission v. Belgium, it's MS 529. Paragraph 90. It's in Authorities 48, Bundle 4. And it's paragraph 90. It's the
And a page number.
I think there are two cases.
There are two Commission v. Belgium. Yeah, I think it's the other one. It's
Bundle 3,
39.
Bundle 3, tab 39,
Oh, I'm very good.
at page 529.
So essentially, the only defence which would be available to Romania is one of absolute impossibility. So a very, very high standard. So in practice, if recovery is ordered, it would not be a defence for Romania to say, well, under either national law or a court order, I was required to do something. So the upshot of these three options, which are really a matter of procedural law under state aid and institutional competence, is that there are a series of distinct possibilities, and in one case, a certainty under option 1, that the Commission either must act or at least would be entitled to act in respect of security and the question of state aid. and the Commission would have exclusive institutional competence to do so, and ultimately the arbiter of whether the Commission will be right or wrong in law to do so is the Court of Justice. And this is significant because the Court of Appeal accepted at paragraph 237 that sincere cooperation would be engaged if it concerned a future Commission decision or action, that caution would be required in that case. And I'll give the Court the quotation. It says, "The position is different, however, once the Commission has issued its decision. Then there is no longer a need to avoid a risk of conflict with what the Commission might decide." So in my options 1 and 2, where there is scope for the Commission to take prospective action, and indeed under my option 1, the Commission would be required to adopt a decision, the Court of Appeal accepted that in that situation, sincere cooperation would be engaged. And the simple point we make is that under any one of my 3 options, it remains open for the Commission to act in respect of security. Indeed, it would be required, in the event of a notification, to act and issue a decision. As I will show the Court after the lunch adjournment, the Commission has indicated in the clearest and most strident possible terms that it regards the payment of security as potentially amounting to state aid, and that it will act to adopt decisions and take other actions to that effect if required to do so. And our essential submission is that sincere cooperation should not be reduced to a game of a national court daring the Commission to do something. Under the EU judicial system, for it to work effectively, there has to be restraint and precaution where the scope for conflict is real and not fanciful. And if one applies this to security, if there is a court order requiring security, and Romania is obliged to notify that, that would involve a breach of the standstill obligation if that security is put into effect. And this would then have a sort of domino effect of a whole series of further decisions and proceedings, both interim and final, and in case of non-compliance, infringement proceedings, including fines, as a result. And we say that as a matter of sincere cooperation, this course of action has nothing to commend it. It would become a game of legal whack-a-mole. It is the antithesis of sincere cooperation. Sincere cooperation, as we saw in Master Foods paragraph 49, requires the national courts to abstain from any measure which could jeopardize the attainment of the objectives of the treaty. It is a precautionary principle to be applied or disregarded only where there is scarcely no risk of conflict materializing. And we say there are a whole series of possibilities or options whereby the Commission either would be obliged to act or certainly could act. I think, yeah, I see the time.
Thank you. That sounds like a suitable point at which to pause. And we shall look forward to hearing from you further at 2 o'clock.